welcome to Thinking Boldly. This is Consilium's video podcast series where we bring in experts to talk with us about issues related to families, family law, and how to make sure that we are doing what we need to do as lawyers, judges, financial professionals, therapists, mental health therapists, anyone who works with families in divorce, are doing the job that families deserve. And we're very honored today to have Angie Arkin be part of that conversation. One of the great premises of Consilium is that the name itself means Council of Wise Advisors. So we are very privileged and honored to bring to you this series that includes wise advisors of people who have given deep thought to issues related to families. So with that, I would like to welcome Angie Arkin to our conversation and do an introduction briefly of Angie. So the Honorable Angie Arkin, now retired from the bench, is a graduate of Emory Law School. She's licensed in Colorado, Georgia, and the District of Columbia. In August of 2000, after practicing law in Georgia and Colorado, Judge Arkin was hired as a district court magistrate in Arapahoe County, Colorado. She was then appointed to a district court judgeship in the 18th Judicial District in July of 2002 and served on mixed dockets for a few years. But then July 1st, 2008, Judge Arkin was assigned to a 100% domestic relations docket that she presided over until her retirement in January of 2016. In 2015, Judge Arkin was rightly chosen as a district court judge honoree for the Colorado Judicial Institute Judicial Excellence Award and has received many other awards and accolades for her service to the Colorado bench bar and Colorado families. Since she left the bench in 2016, she created a self-represented resource center to provide unbundled legal services to pro se litigants. And in early 2017, Judge Arkin joined the Judicial Arbiter Group, where her current practice includes mediation, arbitration, mead-arb, special master and appointed judge service in domestic relations, civil, and probate cases. She is also a leader in creating the Symposium on Race, an ongoing monthly forum for discussion of race issues in Denver, and is spearheading, and this will be part of our conversation today, the Licensed Legal Paraprofessional Subcommittee of the Colorado Supreme Court Advisory Committee. So I have the privilege and had the privilege of meeting Judge Arkin shortly after my appointment to the bench in 2010. And Angie, if I may, has served as a mentor and guide for me and is someone that I turn to when I have hard questions or just want to talk through challenging issues or to even vent a little bit. So Angie, thank you so much for being here, being part of the Thinking Boldly series. I'm here with my partner, co-founder of the Consilium Institute, Heidi Webb, and we welcome you to our conversation today.
Thanks for asking me. It's an honor to be here.
Absolutely. We're just thrilled. So I just would like to start with, it seems to me that you are very passionate about families being well served by the courts. As I look at your history, as I look at the work that you do, as I look at the work you continue to do even after retiring from the bench, really it seems like you want families to be well served by the court. Where does that come from? Where does that passion come from?
When I started practicing, which was in Georgia in 1983, I was a family lawyer. I did some civil work as well, but primarily it was representing individuals in divorce And Georgia is a very interesting place because there is in the Constitution jury trials of 12 for divorce. And
Still?
my first ever jury
Oh
trial
my gosh.
No idea.
was my client was 19, his wife was 17, and they had a little girl, and her parents paid for a fancy lawyer and requested a jury trial. And the case that had essentially no assets, the only issue was the custody of the child, which was so interesting because the jury doesn't decide custody. It decides everything else, but not custody. But they were still adamant to punish this poor little guy. And that was my first experience in a jury trial. And it was horrible for my client. It was terrible and incredibly expensive. I never recovered all the fees that I incurred representing him. It would have taken, 30 years. It was very, very expensive and ridiculous. It just didn't make any sense, but it was punitive. Of course, Georgia also had fault divorce, something that Colorado was one of the first states to get rid of. Um, Georgia had fault divorce up until I think the mid 90s. So, very, very different place from Colorado, about night and day, really. Uh, but the way that the courts treated my clients and children and families, uh, it was probably somewhat better in Colorado because the laws were better, but there aren't a lot of judicial officers who have a background and experience in family law. It's just not something that people have as a platform from which they um, strive to be a judicial officer, a magistrate or a judge. And that's just kind of interesting, but it's problematic because, and this is true pretty much everywhere, but family law is very, its structure is very much uh, filled with discretion, and that makes sense. Every family's different. Every family comes to the court with different issues, and every family created itself differently.
Mhm.
You know, that's something that's true. It may not be true in every country, but it sure is true in the United States that unless you're doing something illegal, like harming your kids or harming each other in some way, you can kind of make whatever family you want to make.
Mhm.
And so when you get to the courtroom to undo the marriage, the laws have to be structured in a way that allows the court the discretion to see as best it can uh, what the issues are and figure out how to move that particular family forward. And so much of that is related to how you structured your own family and how you created that family and the history that you intended and unfortunately failed.
Mhm.
So, and of course, those hopes and dreams that are no longer going to happen.
Mhm.
And that's a lot of fallout.
Right.
People who are in the process. I mean, it's like your dream comes down and covers you with goo, and you have to kind of dig out from under it before you can really see the future. And that comes with an awful lot of arguably narcissism and concern and fear and worry, sometimes anger, often pain. It's just challenging. So you have this family that nobody can give you a really unbiased opinion of because neither party sees it clearly. And both parties are traumatized, are unhappy, are unwilling to acknowledge many realities at that point, even if they've done good work with therapy and um, good legal representation, they're still going to be probably struggling somewhat in trying to figure out what happened, what their own contribution was, if they acknowledge they contributed, um, you know, how to help their children through it, how to actually see their children in the process as something other than, somebody, one party or the other owns. You know, those are struggles that many, many families go through when they're divorcing. And judges in particular are not terribly well equipped to deal with it.
I'm hearkening back to something you said early on. I just sort of can't quite get my head around it, and I just want to ask you about it. All of what you're saying resonates so deeply. But when you were talking about the idea of a jury trial, except in issues of custody in Georgia, can we just revisit that for a second? Because does it have to do with sort of a dissolution of the marital assets, that they're looking at that in terms of an equity issue, and a jury's weighing in on that, or what else is not considered in that?
Well, so at that time, and I'm not certain currently if it's still true, but at that time, Georgia was a fault state.
Mhm.
So you could get a no fault divorce in 31 days in Georgia. I mean, it was fast and easy.
Yeah.
But if you didn't want to get a no fault divorce, you can you could claim cruel treatment.
Right.
Um, you could claim adultery. You could claim all sorts of things. And in Georgia, if you proved adultery, there was no alimony.
And what the jury could weigh in on, basically, in terms of a family structure, which leads to all the other things that you're talking about. So, how much of this was a social context and how much of this was a family, the microcosm of a family, and how much was it, not, if not typical, not atypical, that a social context would weigh in on a family dynamic, like,
Oh, that was the whole point.
yeah.
That was the whole point. Your community gets to judge you in this very private family dissolution. And
Mhm.
seriously, it was in the Constitution in Georgia that you had the right to a jury trial of 12, a jury of 12. So it took 2 to 3 years to get to a jury trial because, you know, it just, the courts, the way they were structured, the terms and blah, 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 it just, jury trials were all clumped in together, and domestic relations, divorce jury trials often would be continued for years. Um, so it was a way to strong arm the other person, to starve them out, to force them to take a settlement that they didn't want.
And were all things on the table aside from custody?
Yes.
Wow. So it's interesting that you talk about, the jury and how, and we look at that and we're like, oh my gosh, that just
I
seems
know.
absurd, right? But on some level, when you have judges that don't have family law experience, and as you said, are kind of applying their own belief system
Right.
on these discretionary things, are we better off with judges? Are we, what can we do to make sure that judges are not in that same position that the community members are, where they're just deciding based on what their own experience is, but really are able to focus on what they need to focus on. Does that make sense?
Yes, and I think we're always better off with judges regardless because, the War of the Roses in a courtroom is just it's a disaster, especially when there are children involved. Um, you know, uh, Domestic violence cases. I mean, it was pretty regular in these cases involving jury trials in Georgia that there would be each side would hire a private investigator, and they dig up all the dirt they could think of. Who amongst us is perfect? I haven't met that person. I look in the mirror every day. I haven't met that person. So it was just catastrophic for particularly the children, if there were children, to go through this horrible public shaming,
Right.
essentially. I mean, if you're asking my formative time learning about how problematic conflict and um, lack of understanding of the complexity of what families go through can harm people permanently.
Right.
I mean, they can harm adults. So clearly, children are significantly even more harmed. And of course, the ongoing conflict, which, if you have an ugly conflictual divorce, often sows the seeds for many, many more years of conflict. I mean, every once in a while, it's wonderful that people who go through this horrible divorce, they bury the hatchet, they move forward, they figure out how to get rid of the pain and the struggle. Um, Quite unfortunately, way too many of them are so stuck by the time they get to that ugly place of post decree. um, they can't they just can't move forward with their own lives. They are too entrenched in the conflict to be able to see the future. We are. We all have to move forward. It's just where forward is for you.
Mhm.
Yeah.
I think that, just the neural pathways that get sort of trodden in a trial sort of become a go-to for many people. Just it becomes their learned expectation that this is what this experience, it's sort of what they default to.
Right.
Sometimes subconsciously, I think it's not even that they wish to continue on that path, they just can't get out of their own way. And I think that is, clearly, a flaw of the process when
And
we're
I think one of the challenges it is, and as I'm thinking about, the community deciding versus a judge deciding, the judge has the advantage that they know the law, but they don't necessarily know or understand families or family dynamics or what tools they have that they can implement to help that family become self-governing after divorce, which was always one of my goals when I was on the bench. So you've talked, Angie, about your passion and how you how where that came from, but how have you in your career implemented or manifested that passion into action?
Well, kind of wanted to be a judge from the time I was in law school because I always saw gray.
Hmm.
Um, and weirdly enough, I always felt like judicial officers were problem solvers. And that's what we were supposed to be. Um, and even before when I was first hired as a magistrate, I had the opportunity to teach at what we call in Colorado baby judge school. It's new judge orientation, but um, I started doing judicial training, and I had done presentations for many years, but had an opportunity to talk to judicial officers from the place of being one. And I think it was something that Heidi said, but well, actually, something Julie was talking about with respect to judges judging. One of the things that I have really tried to teach judges more than anything else is not to judge too much. So much of the art of being a good judicial officer in the family context is recognizing the family's choices and not judging them, just figuring it out. Because, the challenge is always people come into court and they tell you their truth, but it's not the truth. And finding the truth is not what we're supposed to be about. It's just figuring out sort of the path forward. That being said, the more you judge what other people chose to do when they had no idea they would ever come to see you, that's horrifically unfair, and it's burdensome on them because when they made those choices, they didn't do it to please someone else, to get accolades or props from anyone. They did those things because they thought they were best for themselves or their kids or their spouse at that time. They gambled for a living. So what? They did this, they did that. It's just a normal human thing to judge people. And making a good judge is minimizing that. I used to talk about, I did a little prosecution in Georgia for a little while, mostly related to child support enforcement and things like that. But there's a point that comes where your knee starts to jerk, which is very, very dangerous because you're supposed to be fair. But you start reacting in a particular way to a particular set of circumstances, and you stop seeing the human beings for somebody that are individuals. You just see, oh, this is the right thing to do or the right result, blah, blah, blah. And when I became a judicial officer, I felt my knee would jerk sometimes. And I would look at my knee and I'd go, what's going on? They call it mindfulness now. It used to be just sort of recognizing your triggers. What keeps you from listening the way you need to, from hearing what you don't know, what you thought you might know, but really isn't what you knew, and choosing a path that is consistent with what's best for this family. Now, regardless of how you do that, it's always going to be dangerous because your judgment of what's best for people is never as good as their own. But every time I had a case, I would always tell the people, I would make an opening statement to them and say to them, you're not going to like what happens here. And, over the years, I learned to do that earlier and earlier in the process to try and get them to come to their own resolution, because what do I know? And that road, it's not clairvoyance. It does not give you anything but the power to decide. But brilliance ability to manufacture money, use a crystal ball, see the past, see the future. None of that comes with it. What?
Yeah. The oxymoron of judges needing to be non-judgmental in order to be effective is such a brilliant way to express that, because I think that, people do think that the robe comes with all the power that you just so clearly stated it does not, but yet you do make a decision. So, for people to cede their power to the court, knowing that it may come with bias or not, it may come with the judge's own personal history and reaction and triggers or not, it may, all these things are sort of multifactorial, but do you want to throw your lot into that, or do you want to take control for yourself and create your own vision of your future, as best you can, understanding you may need some assistance and guidance with some of the details in terms of framing it and how you get there. But I think that's just such I don't think I've ever heard a judge claim the importance of being non-judgmental, and I think
Well,
that's
what I'm admitting is that I wasn't always perfect in that. Of course not. And that's the challenge of going to court, because nobody is perfect, and perfectly non-judgmental doesn't exist. But trying to help people see that being judgmental is not our role. It's not our job. It's not what judges should be doing in a family court.
One of the things, Angie, you shared with me earlier is your favorite quote from Abraham Lincoln. And I think that what you've been talking about seems to resonate with the humility of that quote. Do you want to talk about that for just a minute?
I mean, breathing is about learning, and everybody can teach you stuff. And if you are open to constantly learning, then you're going to be much more able to navigate the world. The quote is, every man is my superior in that I can learn something from him. And when I sent it to Julie, I said, every person is my superior in that I can learn something from them. But Abraham Lincoln wouldn't have said that.
we
Different
would
times.
if we were living now.
Different times, yeah.
But everybody brings something to the table that's important and that can be helpful to everybody else, if you're willing to look for it and to listen to it and to see it. Doing what Julie and I did for so many years, you see plenty of quote unquote bad parents, people who said or did things to their kids that are just horrific and unpardonable. And even the lesser, but not entirely horrific and not entirely unpardonable, but just harmful. But most of those people, and I don't know that I've ever met any of them that didn't have other things about who they were that actually were qualities their children benefited from. And it was always incredibly hard and challenging to say, no, this parent can't have contact with this child ever again, because what you're saying is there's nothing about that human being that they have to contribute. And that's so rare and unusual. And part of what judges should be doing in family court is recognizing that which is positive and trying to maximize it. And that isn't just for kids, it's also for the marital estate and the opportunity to be supported, but also find independence and move forward and blah, blah, blah. All of those things. And I don't know how you felt about it, Julie, but every once in a while you'd be in a case and something really magical would happen. Someone would say something or a bunch of information would come in and you'd just be like, wow, this is the answer
Mhm.
to help.
Yep.
Um,
Yeah, absolutely. And it is magical.
it is.
And it's magical to reflect that back to the parties and say, wait, did you hear what you just said or what
Oh, that's
said?
the
Or
coolest.
yeah,
Yeah.
yeah, that is the coolest because it does lead to that self-recognition for the parties that they do have control over this, that they can make choices that benefit themselves and their kids in the future. Yeah.
Well, there were also times when we would get through half the day and I would call counsel and maybe the PRE or the CFI back into chambers with me and I would say, okay, so here's what I just heard and here's what the law says. And if I have to decide this, this is how I'm going to harm everyone in that room. You guys, what you might be able to think about doing that would be better. But what I just heard, I only have one road to go down because I'm a judge and I have these guardrails around
But
my ability to do something better
Yeah.
than, what I'm stuck with based on the evidence I've heard so far. And, I've only heard half the case, but, I'm just terrified that this is going to be incredibly harmful.
Mhm.
And maybe you guys can put your heads together and come up with something better.
I think both the humility sort of in your doing that and for for lawyers to sort of own that it may take more of their work to do the thinking that you're requesting than to defer to the law and your judgment on that is really powerful. And for litigants, to hear or to understand that the judge is giving them another opportunity to be creative, to think for themselves, to think outside the box, to have that the grace of that opportunity, I think, is huge when people may feel sort of disinclined to take it because they've been told or instructed that they might have an advantage or it might go their way more favorably, or they've been posturing for a certain outcome. And then you're in that position and you're hearing the person who has the power say to you, but you might want to rethink this. I think that's incredibly powerful, in that forum.
But there are just times where the law says this has to be the result. And, you know, and every once in a while a lawyer would say, oh, but judge, you're going to hear this evidence or this testimony. And I would say, okay, you're right. I haven't heard the whole thing. But I would just make sure that they were clear that if I didn't find credible that which they wanted to present to me that was going to change my mind, um, the harm that was going to come to the family, um, it was all I could do. And I just always struggled in those situations because I I, I just always felt like and often what was so cool is that often they did come up with something much better.
But I think that for a lot of it, at least in my experience, that for a lot of people, the law is confounding and it becomes sort of this obscured process. And so the lack of transparency about what a judge can and can't do becomes unclear. And then people become fixated on an idea of what they think a just outcome would be, or what they've been advised they might get. And, all these things sort of come, and it's very difficult when you're in sort of an agitated state emotionally to have your logical brain engage enough in a process that recognizes, wait, what I'm being told is that this outcome might not be possible, that the judge has limited resources or ability to make a judgment. I think that's a really just a testament to how you sort of handled your courtroom, but also just, I think, a process that in and of itself can be really confusing to people going through it. At least in our work at Concilium Institute, we're so trying to give credence to sort of all of what you're saying and what families bring to the fore, and how children need to be heard in and respected, even though they're, don't have the experience and other sort of advantages of adults. In many ways, they still have feelings that need to be acknowledged and appropriately given credence.
Well, and Angie, I know you and I both had lots of self-represented litigants in our courtroom that we felt like, at least I felt like I needed to educate them enough about the law so that they could give me the information that I needed. And I know one of obviously judicial education is one of your great passions, but the other passion I think is making sure that people have resources so that they can go into court and have that ability to share their information in a thoughtful, complete way with the court. So I'd like to turn a little bit and talk about all the great work that you've been doing over the past several years on the licensed legal paraprofessional committee, and what that looks like and where that came from. So, that's a new concept here in Colorado. It's a new concept in most states, but just tell us a little bit about that and what it is and what the goal of it is, and where it came from. And we might interrupt you with questions because it is such an interesting innovation.
Well, 2015, Washington State came up with these paraprofessionals called triple LTs, limited license legal technicians. And they were the first in the country. And these triple LTs practiced family law. That was the only area that they were licensed to practice in. But it was innovative, and Colorado heard about it, and the Bar Association formed a committee that was, 50 plus people. It was ridiculous because everybody was terrified. Oh my gosh, this is going to take over our profession and ruin lawyers and law and blah, 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 blah. And very shortly after the concept was originally proposed in Colorado, the bar said, hell no. We don't want these people in Colorado. Absolutely not. So there were some access to justice focused folks, and some judges, a guy named Dave Stark, who is the chair of the Supreme Court Advisory Committee. They kept working on the concept of having paraprofessionals assist people in smaller, less complicated matters. And in 2019, they made a proposal to the Supreme Court in Colorado to have paraprofessionals assist people in the landlord-tenant area with evictions. And the Supreme Court kind of thought about it, and they came back and they said, we know these people need help. But the people who need the most help right now in Colorado are litigants in domestic relations cases. And more than 70%, I think at that time it was about 74% of litigants in domestic relations cases were going self-represented. And the Supreme Court said, it's a great concept, but where it's really needed, the screaming need right now, is in family court. And a lot of that was related to the fact that people weren't problem solving very well without any legal advice. In fact, the forms and the process itself were so daunting for the public that many people would just separate and not deal with their divorce for years.
Right.
Because it was so complicated to try and get a divorce. And Colorado had done, we had hired what we call Sherlocks, which are individuals who are in the courthouse sort of giving out legal information and helping people figure out the forms and things like that. But those folks were completely overwhelmed. And years before, we had these family court facilitators who would meet with people for their initial status conference, but they didn't have time to work with the people individually. And of course, none of those folks could give people legal advice. So in January of 2020, I received an email from a justice on the Colorado Supreme Court, Melissa Hart, and she said, we're thinking about creating a paraprofession in Colorado, and we don't know your position on it, but we thought you might be interested. And if you're not interested, or if you're against the idea, can you give us the names of people who might be interested? And Justice Hart is this incredibly thoughtful person who became a Supreme Court justice because she would like to make change. That's who she is. And she's very interested in thoughtful ways to move the legal profession forward for the good of everyone. And I thought to myself, when a Supreme Court justice sends you this kind of an email, you kind of say, of course, I'm interested and I'd love to help. So I became a co-chair with a woman named Maha Kamal, who's an attorney who did unbundled legal services, and who I knew from appearing in front of me down in Douglas County. And the two of us became the co-chairs. And Jessica Yates, who is the Supreme Court Office of Attorney Regulation Counsel, who recognized that this would create tons more work for her office, still supported strongly the idea that a paraprofessional could be very helpful to family litigants in Colorado. So we started meeting in March of 2020 virtually. Well, I was virtual, everybody else was in person, but after the first meeting, we were all in Zoom, and we've been pretty much in Zoom forever since then, and it took 4 years. In the meantime, we are blessed with a Supreme Court who is filled with folks who sat on the domestic relations bench. I think it's fair to say that 3 of the 4 judicial officers, they were district court judges before they were Supreme Court justices, were mentees of mine when they were in domestic relations. And in November of 2022, when we had our hearing in front of the Supreme Court, well, they've been unanimously in favor of this since the beginning. but literally it was 3 justices who said to us, why can't they do more?
Mhm.
Why can't these licensed legal paraprofessionals help people more? Why do we have these limits on their practice that may constrict them from being more helpful to people to get them through the process? And of course, one of them, Justice Birkenkotter, was committed to the perspective that LLPs, licensed legal paraprofessionals, which was the name we came up with for them, would help people settle. Because sometimes just the smallest bit of legal advice, understanding what you have the right to ask for, and understanding what you can walk away from and give up, but really understanding how that impacts you and the choices that you're making and the realities financially and in terms of how it might impact your child to fight for this or that kind of parenting plan or this or that kind of child support. Those little things can be really impactful for people to understand how to find their own solutions.
So can I ask you a question? Just in terms of the training of the LLPs and their and people's reliance on their advice in
Right.
terms of, yeah, I guess those are my 2 questions.
So, the minimum to be a licensed legal paraprofessional is to have a paralegal degree or a bachelor's with 15 hours of paralegal studies or a law degree from another country that wouldn't give you the right to a law degree, to a bar license in Colorado. But you have to have had some kind of legal related training, and that's what we call Path A, plus 1,500 hours of actual paralegal experience or law related practice experience, I think is the term that we use. And 500 of those hours have to have been Colorado family law practice hours. And the term isn't specifically defined in the rule, but the committee defines that as actual interaction with clients and helping people in their actual cases. So being a law clerk for a judge or being a researcher for a professor who's a family law professor, those kinds of things do not qualify you to do this, because when you get licensed, you will be engaging in the practice of law. And you can be independent. You can have your own practice.
So you'll be licensed to practice law in this limited way, and presumably there are malpractice providers who are, you
Yes.
know, assuming this liability
Yes.
potentially. Um, so, but you're not a lawyer, but
Right.
you're a paraprofessional with exactly what it says. So limited legal abilities, giving legal advice. So it really, it's sort of, I could imagine that the bar was, not happy about this, or many. I think that the idea is that there are so many people who those would never go to a lawyer, couldn't afford a lawyer, couldn't take advantage of all of the advice that they might get if they went. So that this is sort of like giving them more than they would otherwise have, and they're for cases that aren't so complex that they would require sort of the next level of sort of legal thinking or case analysis, or things that would be have a higher need in terms of legal skill. Is that correct?
Absolutely. So if you want the easiest analogy for most people to understand, so you're out in the hinterlands of Colorado and there's no doctor.
Mhm.
And so people aren't getting health care where they are. and a nurse practitioner or a PA moves to that area. And now, instead of no health care, they're getting some health care. In fact, they're getting some pretty high quality health care, but it's not complete. But before, they had nothing. Okay, this is nothing versus something. This is not LLP versus lawyer, because these people weren't hiring lawyers and they never would. Both because they couldn't afford it, and there were a lot of people who could afford lawyers but didn't want to spend the, 25, 50, 100,000 or more to litigate their divorce. So they would go it alone, but badly. But having this nurse practitioner can really help you identify what the challenges are in your dissolution, in your family system, and move forward from there. And get enough advice if it's not a complex situation. And complex is defined pretty much as trusts, marital agreements, jurisdictional conflicts, litigating really tough stuff. Experts required to value property or value an income stream. So wage earners, folks who are self-employed but not high earners, the general folks who couldn't afford any sort of legal assistance. And Colorado has had unbundled legal services since, I think, 2001. That being said, there are an awful lot of lawyers who don't provide it. There are an awful lot of litigants who don't understand what it is. And they certainly don't take advantage of it, even when it's available to them. And there are plenty of folks who really can't get through the process without that sort of hands-on assistance. And LLPs can actually go to court with people. They can sit with them at counsel table. They can make an opening statement. They can make a closing argument. They can't question witnesses, but they can help the person feel comfortable enough, and they can answer the judge's questions, explain what the judge just said to the party. It's just a level of assistance that we're trying to keep people out of court. But even when they have to go to court, at least they're not there all by themselves. And for the judges, oh my goodness, they don't have to figure it out. They don't have to ask 30 questions to try and understand what the equities are, just in order to do equity.
And are they drafting agreements or not?
Yes, but primarily by using the forms.
Are there defined jurisdictional limits? I mean, you talked about some of the things, like if it's
No jurisdictional conflicts.
overly complex, or okay.
No, not complex jurisdictional conflicts. Any jurisdictional conflicts, they cannot. They have to refer the person to an attorney, or just stay in the case but not handle that piece of it. If there's a trust, if that has some impact, if there's Sinheit, a marital agreement that needs to be litigated, if there's, as I said, if you have to hire an expert to value assets. Now, of course, I'm guessing it's true in most places, but in Colorado, if you own your house, you can opine as to its value. So if you had an appraisal beforehand, you can opine as to your house's value based on that appraisal, and it's not inappropriate for you to do that. So, if that case isn't settled you can go into the courtroom with your LLP and just get on the witness stand and testify as to the value of your car and what value of your house and, basic stuff.
Right.
But they can't draft qualified domestic relations orders. They can't draft documents that transfer businesses. They can't, they can do parentage determinations, but not with multiple parents. If there are more than two possible parents of a child, they are not able to do that. So
Ones. So, how many applicants have there been for
over
your program?
70 people have qualified to take the exam.
Okay, and the exam is being given
April
almost as
30th.
we speak, right?
April 30th, it is 6 hours.
Okay.
Everybody has to take an ethics class like you do in law school because legal ethics are complex. So the Supreme Court decided that they wanted everybody to take a legal ethics class. So that was developed. We had input into it. We didn't develop it, but the Community College of Denver is piloting the ethics class. There's also an advanced family law class that's optional, but recommended. There is a 19-page document that a bunch of judges put together. We spent hours and hours and hours, and it is called the Core Competencies. And that is the list of all the things that people need to know in order to engage in the limited practice of law.
Be helpful for lawyers, wouldn't it?
Yeah.
Well, LLPs will probably know more than baby lawyers who start practicing DR, for sure.
Absolutely. What's the citation to the Colorado rule?
It is Colorado Rule of Civil Procedure 207.
Why do you think this is a game changer? I mean, I think you've sort of talked about it a little bit, but why do you think this is a game changer in Colorado?
Well, I mean, if you look at it from the perspective of the bench, unfortunately, what sometimes happens is that people who are brand new to being a judge are thrown into family court because it's easy, right? And so they go into a courtroom with more discretion than in any other discipline. And they have no background or experience in family law, and there's no lawyers. There's just two individuals who have no idea what the court needs to know and what they need to share and what what their rights are, all of these things. So it's kind of an unmitigated disaster for the court in that situation. And an LLP can help the court at least understand what the issues are and what might be important to ask about, if nothing else. You could say that an LLP would be providing the court with significant information about what the issues are and how to assist these people in moving forward. So that's sort of from the court perspective. But if we're hoping that those cases, most of them don't get to court because people will have the assistance to fill out the forms, to understand how to negotiate a parenting plan and what the parenting plan actually means, and attend mediation and negotiate the financial stuff if there's financial stuff to negotiate, understanding the maintenance guidelines, which are very complex in Colorado, just all sorts of things. Really hoping that a handful, at least, if not the majority, of LLPs will do unbundled services. They are expected, just like lawyers in Colorado, not required, but expected to do pro bono, just like lawyers. They have a CLE requirement. And we're hopeful that they become staples in the family law community, and that lots and lots of the public learn about them and rely on them for assistance in like 70 to 80% of divorces that are relatively simple and straightforward.
We're going to pause here for a second because Heidi needs to step off. She's got an appointment, but I would like to just continue the conversation briefly, Angie, and don't want to keep you too much longer.
Really apologize, but I do have to run to this appointment, and I have a dog that's being resistant and barking.
So I guess my last question, Angie, just on the LLPs is, how do you know yet how people plan to use it? Are they going to be within a law firm, like paralegals that are already in a firm, or are there going to be standalone or some combination, I guess, maybe depending on the area, right? The region of the.
Probably more the former, especially in the metro areas, more the former than the latter. There are a number of firms, prominent family law firms, who are actually supporting their paralegals through the process. I know the Harris Law Firm, Griffiths Law, just a number of prominent family law firms that have paralegals who have notified us that they're signed up and interested, and
Right.
so they're being supported through the process. So the firms will have them as sort of another option service to offer their clients. There are some folks who are looking at starting their own, entity, their own LLP firm. It's probably a little scarier. On the day after the LLPs are sworn in, we have a practicum that we're doing for a full day at CLE of Colorado, Inc. that will be teaching LLPs all the stuff they never did before, which is interviewing clients, going through the decision making for discovery, looking at preparing clients for mediation, and appearing in court. So paralegals have never done that. And so the practicum's focus is to help them with tools to actually do what they are now licensed to do, which we haven't had the opportunity to do before because there were no folks who were licensed. But I do anticipate there will be some. And at that practicum, the first session in the morning is a triple LT from Washington, an LPP from Utah, and an LP from Arizona, all of whom have their own practice. And the title is What I Wish I Knew. We all have something to teach each other, right?
Right. How many other states have something similar?
Well, my understanding is there are 25 states who are either in the process of licensing paraprofessionals, have licensed paraprofessionals, or are looking at seriously going down the path of licensure. And that's pretty much from the Institute for the Advancement of the American Legal System, who is very engaged in monitoring what's going on in this space. So, that's one of the things. And I would say the majority of the paraprofessionals in the United States right now in this space are practicing family law, because that's where the need is the greatest.
Okay. Well, you must be excited that it's coming up, that it's going to be
excited, relieved. Yeah.
Mm-hmm.
Creating a legal profession. Oh my goodness.
Mm-hmm.
Yeah. A lot of work. Who would have thunk?
Yeah. Well, Angie, thank you for taking time to talk with us today. Thank you for your brilliant leadership in Colorado and really nationally in judicial education and in this endeavor that is going to change the way that families experience court in Colorado. It is just
Or
so,
don't.
or
Which
don't. Right.
Even better.
Exactly, even better. I know that that when people talk to me in mediation or in the community, the legal community, everyone says, "Do you know Angie Arkin?" Uh, and I always say, yes, she is one of my heroes, my inspirations,
Right back at ya.
and I'm also honored to say a dear friend. So thank you
Wow.
for your leadership and passion for caring for families in Colorado. We also, we've discussed featuring you with a national panel of experts, judges, to talk about judicial education, and we are setting that up. We've got some folks that we're recruiting and should have more information about that for everyone in the next month or so. So thank you so much.
I will be honored to join a group of folks who actually like this work, crazy as we are.
You and me both, friend.